Hi, I'm Dustin Saldarriaga, an immigration lawyer with Scott Legal PC in New York City. And in this video, we're continuing our series on the E-2 visa. In the series so far, we've been looking at the E-2 investor visa requirements. In this video, we're taking a look at E-2 visa denials, common reasons for why they happen, and what the applicant's options are following a denial. Before we dive in, if you're interested in more information about the E-2 visa and its requirements, we've posted to our YouTube channel our full webinar on the E-2 visa. We also share a lot of free information about the E-2 visa and other visas on our blog. We'll link to both our blog and our YouTube channel below. Finally, please remember that no video or blog post can replace the value of working directly with an immigration lawyer who can navigate the specific nuances of your application. This is true for any E-2 application and is especially true if you're reapplying after a denial. So let's talk about E-2 visa denials. Our firm has processed hundreds of E-2 visa applications. Our approval rate is about 98%, but we must emphasize that past results don't predict future outcomes. Though the approval rate is high, some of our prospective clients have asked about the 2%, specifically why an E-2 visa application might be denied and what can be done after a denial. Keep in mind that the government officer deciding whether to approve an E-2 application has a lot of discretion, particularly at a consulate. As a result, the officer can generally deny an application for a broad range of reasons. However, some of the more common reasons for denial, in no particular order, are the following. Reason number 1, the officer is not convinced that the business will employ U.S. workers. This is called the marginality requirement, and in summary, it requires that the business generate enough income to support not just the E-2 investor and any family members that join them in the U.S., but also 3 to 4 full-time equivalent U.S. workers within 5 years of the business starting normal business operations. This could happen if the business is a startup and the business plan doesn't project enough jobs, or if the jobs that are projected are not supported by the financial information and assumptions in the business plan. This could also occur if the applicant has operated a similar business in the past that did not employ workers, or if the business was purchased, if it doesn't have a track record of employing workers. For much more information on the marginality requirement, check out our separate video on this requirement. Reason number 2, the amount of money invested into the business is too low. Under the investment requirement, money must have actually been spent on the business and cannot simply be sitting in a business bank account. The actual amount that must be invested depends on the type of business and other factors that we discuss in our separate video on the investment requirement. But generally, any investment amount under $100,000 US could raise questions. Reason number 3. The nature of the business causes the government officer to think it's passive or speculative. For example, businesses focused on real estate investment or stock trading usually receive additional scrutiny, mainly because the government wants to be sure that the business will require the investor's active involvement and direction, and that the business will lead to the employment of U.S. workers. In general, the more speculative the business, the more E-2 visa scrutiny it will face. Reason number 4, the location where the application is filed. Some consulates are simply tougher to get approvals at. For example, some consulates don't receive many E-2 applications and therefore might not understand the justification for an approval. Other consulates see many applications from large businesses, so they might be inclined to deny an application from a smaller business that would likely be approved elsewhere. Also, consular officers are rotated every few years, so policies at a given consulate can and do change, making a more reasonable consulate more difficult overnight, or vice versa. Also, if the applicant is applying for E-2 status from within the United States, USCIS could focus on different aspects of the application than a consulate would, such as the source of funds invested into the business, which USCIS tends to closely scrutinize. Reason number 5, the officer you get. This is simply luck of the draw. Some officers are reasonable and fair, others are unreasonable and even rude and condescending. Since the decision whether to approve or deny a visa at a consulate is largely discretionary, an officer's mood can sometimes make all the difference. Finally, reason number 6, the applicant simply did not meet the E-2 requirements. Some clients have come to our firm after they received a denial. In some of these cases, the applicant was clearly not eligible based on the initial application. It's critical that the applicant understand all of the E-2 visa requirements and how they apply to their specific application. Our YouTube channel, blog, and webinars are good places to start to understand all of the E-2 visa requirements. So, your E-2 visa application was denied. What now? If you applied at a consulate, the decision, unfortunately, cannot be appealed. In fact, U.S. courts have generally refused to review visa decisions made at consulates, citing a principle called consular non-reviewability. If you applied through USCIS, the news is a little better, but not by much. When you are in the U.S. and receive a denial from USCIS, you'll have the option to either file a motion to reconsider or a motion to reopen the case. For both options, USCIS, the same agency that decided the application in the first place, is still in charge. As a result, neither option is likely to succeed. Since the applicant does have more rights since they're physically inside the United States, it may be possible to sue USCIS over the decision. However, this is a time-consuming and typically expensive option, and the outcome is usually far from certain. As a result, usually the best option after a denial is to learn from it and apply again. You'll be required to pay an additional application fee, but the consulate and USCIS will usually give the resubmitted application a fair reconsideration. If you receive a denial from a consulate, be sure to get as much information from the consular officer as you can about what questions or doubts they have. Try to remember all the questions the consular officer asked you and write them down, along with the responses you gave. These will probably be the questions that come up during your second interview. Also, consulates will often provide an explanation when they deny the application, though they're not required to do so. When you apply again, it's essential that you demonstrate that you've addressed any concerns that the consulate had. Though your application might not be reviewed by the same consular officer, the officer who does review the resubmitted application will usually have access to the notes that were taken during the initial application. So be sure to address any and all concerns that have already been raised. USCIS will also typically provide the basis for its denial in the form of the denial notice or a request for additional evidence if the application is not denied outright. For example, if your initial application was denied because of a low investment amount, invest more money into the business and provide to the consulate or USCIS receipts, invoices, and bank statements showing that you've committed more funds to the business. If the consulate or USCIS was concerned about the business's ability to employ workers, hire an employee before you resubmit the application, and include with the application documents showing that you've hired and are compensating an employee. It's often most persuasive to show the officer that their concerns were misplaced, rather than simply reassuring them based on projections alone. In terms of when to reapply, the rule is typically to wait until you've addressed the issue. If you're able to address a low investment amount within a week of applying, you can reapply within a week of the initial denial. If it takes you a few months to hire an employee in order to address a marginality issue, for example, you might wait until that time before reapplying. During your second interview, if at a consulate, be prepared to explain with documentation how you satisfy all of the E-2 visa requirements, and in particular, how you've addressed each of the concerns the consular officer raised at your initial interview. We hope this video about common reasons for E-2 visa denials and how to address them was helpful. If it was, please click the like and subscribe buttons below to stay updated on future videos about visa options and travel to the US. Thank you for watching.